You said that's in 15.
Yeah, they gave, I mean, well, I don't know what to do, but they said you could come here for. Yeah. Guess it's like,
This
two things, two shop.
The more I verify the information and sign it.
You here?
Yes.
Hi, Mr. Tunstall?
Tunstall, yeah.
Tunstall, thanks. We'll be with you in a moment. I'm just trying to get everybody here who wants to be here, okay?
Sure.
Thank you.
Yep.
Good morning. Is this P.O. Pedinato? I'm doing really good with names. Yeah, they're not there. Is that how you say her name, Pedinato? It's
Yeah.
timed out. Pedinato, it's timed out? Okay, I'm gonna try to call her one more time, okay? Because she hung up. It's Mr. Pedinato, if you can hear me, press *6 to unmute. Can you hear us?
Hi.
Good morning, we can hear you. Thank you.
Oh, okay, great.
Thank
Sorry, that
you.
was- nobody
Good
really
morning.
talking.
Yeah, we are all good. Okay. Thank you, Kristen. Okay, so good morning. I'm Parole Officer Truscello, and I'm a hearing examiner for the Board of Pardons and Paroles. And this is a preliminary hearing concerning I said it wrong again,
Tunstall.
Tunstall, I will not get that. I'm going to try. Tunstall, inmate number 283585. Today is Tuesday, December 3rd, 2024. And this is a hearing being conducted via video at the Board of Pardons and Parole Central Office and New Haven Correctional Center. Can you please state your full name and DOC inmate number for the record?
Gregory Tunstall, 283585.
This is a public hearing and public. Can you please identify yourself for the record?
Yes, hi, this is Parole Officer Pettinato.
Thank you. This is a preliminary hearing which has three purposes under the Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. And if I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. You should know that if I do find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. And this hearing is also being recorded. The testimony at today's hearing is going to be taken under oath. So Mr. Tunstall and Officer Pettinato, can you please both raise your right hands? Do you solemnly swear and solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God or upon penalty of perjury?
Yes.
Thank you.
Yes,
Thank you. So we're going to go over your rights for this hearing. So first is, or the procedure for the hearing. So first, I'm going to read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify the exhibits filed for the record. The state will then have an opportunity to address the issue of probable cause and the severity of the allegations. And after the state is finished, you will have the same opportunity. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
Okay. So you do have important rights to this hearing, and one of the rights is that you have a right to be represented by an attorney. Do you wish to have representation at this hearing?
No.
Okay, so you're okay with moving forward, because we did get the information from the public defender's office that they just have not been able to have an interview with you. So are you sure that you're ready to move forward today without representation?
Yeah.
So you do have
Yeah.
the right to, so I'm going to ask you just a few more times, okay? Because having representation is important. So I just want to confirm it on the record, okay?
Well, I'm sending the paperwork for the representation for the next hearing.
The next hearing, okay, because yeah, I have a note from them saying that they've been trying to, or that they requested a legal call. They're waiting to hear back. So they've been trying to get in touch with you.
Yeah,
that's
they
why-
haven't.
They haven't been able to. So that's why I want to make sure that you're okay with moving forward today, or we can give you time to make contact with them and continue it out.
No, I mean, this is the preliminary hearing, so.
You're okay with moving forward? Okay, so I am just going to ask you probably 3 more times. Just bear with me, okay? All right, great. So you do have the right to be represented by an attorney, and you may hire your own attorney. And if you cannot afford an attorney, you may qualify for an appointed attorney to represent you. As you just said, that you're going to move forward with representation at the revocation hearing. However, you are comfortable with moving forward today without legal representation. Is that correct?
Yes.
Okay. So the other rights you have to this hearing is that you have the right to receive the written notice of the charges of violation. Did you receive that written notice?
Yep.
Perfect. Do you have the right to review the evidence against you before this hearing? And you have the right to submit evidence in support of your case. In addition, at this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yep.
So now we're going to review the charges that the state, your parole officer, has brought against you. Officer Pettinato, can you please read the charges that you have brought against Mr. Tunstall?
sure. Under release direction, On March 5th, 2022, your GPS battery shut down from 7:34 p.m.
Sorry, can I
until-
just start you over? Can you just say the charge? So the charge is GPS, charge 1 is GPS.
Oh, yes, sure. Charge 1 is
Thank you.
GPS.
Yep.
On March 5th, 2022, your GPS battery shut down from 7:34 p.m. until 12:34 a.m. on March 6th, 2022. You failed to charge the unit in accordance with your GPS agreement. On February 6th, 2023, your GPS battery shut down from 7:37 p.m. to 1:28 a.m. on February 7th, 2023. You failed to charge the unit in accordance with your GPS agreement. Under curfew, on February 27th, 2022, you failed to return home from work as directed and were in various areas of Waterbury until approximately 3 a.m. on February 28th, 2022. This is a violation of your GPS curfew. On April 30th, 2022, you left your parole-approved residence at 8:08 a.m. and failed to return until 2:15 a.m. on May 1st, 2022. This is a violation of your GPS curfew. Under Obey All Laws, obedience to the law, on September 26, 2024, you were the driver of the sole occupant of a vehicle that crashed into a telephone pole and broke a mailbox. A warrant was written to obtain your medical records, and it was confirmed that your blood alcohol content was 0.20 gram %. A warrant was written for your arrest, and you were subsequently charged with violation of Connecticut General Statute 14-227A, operating under the influence of drugs or alcohol, and 14-36A, failure to maintain proper lane. This is a violation of your special parole condition, Obey All Laws. Under drugs, on March 1st, 22nd, you submitted toxicology, which tested positive for the presence of cocaine, and you submitted signed a voluntary admission form. On March 7th, 2022, you submitted toxicology, which tested positive for the presence of cocaine, and signed a voluntary admission form. On September 14th, 2022, you submitted toxicology, which tested positive for the presence of alcohol, cocaine, and fentanyl, and signed a voluntary admission form. On February 7th, 2023, you submitted toxicology, which tested positive for the presence of cocaine and benzodiazepine. You signed a voluntary admission form indicating this to be true. On June 16th, 2023, you submitted toxicology, which tested positive for the presence of cocaine, and you signed a voluntary admission form. On November 3rd, 2024, according to the Watertown Police Department incident report, you were involved in a medical incident that was classified as an overdose. You took a narcotic and became unresponsive. When the PD arrived, you were blue and had labored shallow breathing. You were administered 2 doses of Narcan before your body became responsive, and you were treated at Waterbury Hospital for a drug overdose. Based on your actions, you are in violation of your standard special parole condition, Obey All Laws. Under no consumption of, this is under additional conditions, no consumption of alcoholic beverages. On March 21st, 2022, you submitted toxicology, which tested positive for alcohol. The consumption of alcohol is a violation of your additional condition. On July 7th, 2022, you signed a voluntary admission form indicating that you drank alcohol. On September 14th, 2022, you submitted toxicology, which tested positive for the presence of alcohol, cocaine, and fentanyl, and signed a voluntary admission form. On September 26, 2024, you were the driver and sole occupant of a vehicle that crashed into a telephone pole and broke a mailbox. A warrant was written to obtain your medical records, and it was confirmed that your BAC was 0.20 gram %. A warrant was written for your arrest, and you were subsequently charged with violation of Connecticut General Statute 14-227A, operating under the influence of drugs or alcohol, and 14-36A, failure to maintain proper lane. All these behaviors are a violation of your additional special parole condition, no consumption of alcoholic beverages.
Thank you. So in regards to charge number 3, the condition of Obey All Laws, a judge of the Superior Court of the state of Connecticut has determined already that there's probable cause to believe that you committed the crime of Connecticut General Statute 14-277A, operating under the influence of drugs and or alcohol. So we're not going to revisit this finding, and the charge will not be considered at this hearing. So we don't need to speak about it, take any statements or testimonies, as probable cause has already been determined, okay? So now we're going to move on to the evidence. Pio Pedinato, can you please identify all the evidence you have submitted for the record, please?
Sure. Yeah, sorry, hold on a second.
That's okay, take your time.
I'm going to pull it up. Okay, Exhibit A is the conditions of special parole. Exhibit B is the previous decision informational summary. Exhibit C is a GPS agreement. Exhibit D is a parole violation report from June 10th, 2021. Exhibit E is a revocation summary from September 24th, 2021. Exhibit F is a misconduct from March 1st, 2022. Exhibit G is a voluntary admission form, March 1st, 2022. Exhibit H is his position history summary from February 27th to 22 until February 28th of 22. Exhibit I is the Allied Universal Report from March 1st, 22 through March 6th, 22. Exhibit J is a misconduct from March 7th, 22. Exhibit K is a voluntary admission from March 7th, 22. Exhibit L is a misconduct from March 21st, 22. Exhibit M is a voluntary admission form from March 21st, 22. Exhibit N is Allied Universal Report from April 29th, 22 to May 1st, 22. Exhibit O is a misconduct from May 2nd, 22. Exhibit P is a misconduct from July 7th, 22. Exhibit Q is a voluntary admission from July 7th, 22. Exhibit R is a misconduct from September 14th, 22. Exhibit S is a voluntary admission from September 14th, 22. Exhibit T is Allied Universal Report from February 6th, 23 to February 7th, 23. Exhibit U is a misconduct from February 7th, 23. Exhibit V is a voluntary admission form from February 7th, 23. Exhibit W is misconduct from June 16th, 23. Exhibit X is a voluntary admission from June 16th, 23. Exhibit Y is a Connecticut Uniform Police Crash Report number 2400092640. Exhibit Z is the Waterbury PD Arrest Warrant, case number 2400092640. Exhibit AA is the Watertown Incident Report number 2400019569. Exhibit BB is the remand to custody. Exhibit CC is the judicial pending case detail. Exhibit DD is a parole violation report, and Exhibit EE is the notice of parole violation.
Thank you. Were you able to receive the notice of violation, the parole violation report, and all the other documents that have just been marked for identification purposes?
Yeah, I received all that stuff, although, I don't understand why all this stuff from 2022 is on there, because that was all resolved with my parole officer back in 2022. Like I went to the App Foundation and did several other things in terms of rehab and MCCA and things like that. I don't understand why is all this stuff from like 2.5, 3 years ago concerning what we're doing right now.
So we're going to move. So there's a part of the hearing that you're going to be able to discuss each of the charges. Your parole officer is going to have the first part, but I just want to mark for the record. I did not receive any exhibits from you, correct?
For me?
Yes.
No.
No. And do you need more time to submit any evidence or exhibits for this hearing?
No, I don't have any exhibits.
Okay. So now it's going to be the parole officer's turn to speak upon the charges. Make a statement and testify with respect to probable cause. And once she's done, you'll have your opportunity to speak towards the charges as well. Okay.
Sure.
Thank you. Officer Pettinato, do you have any statements or comments to make towards probable cause for the charges you brought forward?
Yes, I just wanted to say that, so all of the charges and the evidence is just a snapshot of Mr. Tunstall's behaviors and incidents and positive toxicology since he's been on special parole. There was also, before this, an incident where he was previously arrested for a similar situation, which was resolved. He did have a revocation hearing, and that whole situation was, handled already. So all of this stuff is since then. So it does show a pattern, a history, some ongoing issues that he kind of exhibited while he has been on special parole. And the most recent behaviors are concerning, considering his safety. The public safety is at risk. PCS has offered many sanctions, many interventions over the years to try and work with him and try and get him on the right track. So at this time, PCS is just requesting that their finding be made on the charges and that the board determines that it's serious enough to continue incarceration at this time, pending the legal proceedings and the outcome of the pending, the additional charges with his special parole violation. Thank you.
Thank you. Okay, so now it is your opportunity. So I have noted already that you're commenting that these violations are from 2022, correct?
I mean, a lot of them are, and I did programs and things because of that. Like I had a different parole officer back at that time. I was under Officer Ferraro, I believe. And then I had another parole officer in between Pedinato and Ferraro. I think her name was Caruso. But I don't think I ever had any incident with her. I think everything had all the old stuff, the stuff from 2-3 years ago now, that was under Ferraro, and it's not like he just brushed them off. Like he made me do. I had to do all sorts of treatment things, and like I said, including there was one I had to spend a month in the App Foundation. I did a lot of MCCA stuff. I did a lot of. It's not like it was just this happened and nothing happened. Like there was he put me into treatments and things like that. And then until this thing happened, it had been a couple of years since any incident.
I have noted your position for the record. I am just going to take a moment and then I will let you know my findings, okay?
Yeah.
Any additional comments before I do make my finding?
No.
Okay.
No.
All right, so then I am going to make a finding of probable cause for charge number 1, GPS, based on the evidence that was provided, which is Exhibit A, C, I, T, U, and DD. I'm also going to make a finding of probable cause on charge number 2, condition of curfew, based on Exhibits A, C, F, O, and DD. As stated before, charge number 3, I cannot, we will not address, as the judge has already made a finding of probable cause for the obedience to the law. So for charge number 4, condition of drugs, I do find probable cause based on evidence A, F, G, J, K, R, S, U, V, W, X, double A, and double D. And lastly, for charge number 5, condition of no consumption of alcoholic beverages, I do make a finding of probable cause based on exhibits A, L, M, P, Q, R, S, Z, and DD. So I also find that the acts are serious enough to warrant revocation, and I determine that you should be detained while you await your revocation hearing. So the records office will be notified of that. And then once your pending charges are handled and disposed of, we'll get notice from Parole and Community Services to then schedule a revocation hearing for you, okay?
Yep.
Do you have any questions at this moment?
Nope.
Okay, so we're all set. I'm going to go off the record, and this concludes the preliminary hearing. Thank you both for being here. Have a good day, okay?
Good.
All right, thank you.
Thank you. Yep,
I
you're
can
all
leave.
set.
All right.
Yeah, you can leave. Thank you.
Okay.
Attorney Johnson, is that you?
Attorney Johnson, if you can hear me, press *6 to unmute on the phone.
And Mr. Dukes, you can have a seat. We're just trying to connect with your attorney, okay?
Okay.
Thank
Good
you.
morning.
Good morning.
Good morning.
Come on in. With the hand. I'm gonna mute. Attorney Johnson, I'm just gonna hang up and dial you back directly to just get you into the hearing. There just seems to be an issue with the audio at the moment. Attorney Johnson, try pressing *6 to unmute now.
Hello? Yes, I'm here.
We hear you. Thank you so much. Thank
Yes.
you. So good morning. I am Parole Officer Truscello, and I'm a hearing examiner for the Board of Pardons and Paroles. And this is a revocation hearing concerning Martquice Dukes, inmate number 347617. Today is Tuesday,
Right.
December 3rd, 2024. And this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and the New Haven Correctional Center. Mr. Dukes, can you please state your full name and inmate number for the record?
Martquice Dukes. My MA number is 347617.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. Present this morning is also Attorney Johnson. Attorney Johnson, can you please identify yourself for the record?
Yes, Attorney Ronald Johnson on behalf of Mr. Martquice Dukes.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I'll review and make findings of the facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not, the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to the appropriate sanction. My recommendation will then be given to the panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Dukes, can you please raise your right hand? Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God or upon penalty of perjury?
I do.
Thank you. So we're going to go over the procedure for the hearing first. I'm going to read you your rights, and then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify the exhibits filed for the record. The state is not present at today's hearing. However, you will have the opportunity to present any relevant testimony and any relevant documents. After the consideration of all the evidence presented, I will announce my findings. And if I find that you violated one or more of the conditions of your parole, you'll have the opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
So you do have important rights to this hearing, and the first is that you have the right to be represented by an attorney at this hearing, and you have counsel here present for you. You also have the right to receive written notice of the charges of violation. Did you receive the notice?
Yes, ma'am.
You have the right to view the evidence against you before this hearing, and you have the right to submit evidence in support of your case. And in addition, you have the right to call and examine voluntary witnesses or to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, ma'am.
So we're going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So on charge number 1, condition of obedience to the law, the charging officer reported that on September 29th, 2024, at approximately 1:09 a.m., you were involved in an altercation at a bar in Ansonia, Connecticut called The Spot. You were heard by Ansonia police officers yelling loudly and aggressively, attempting to gain access to the bar after being escorted out earlier in the night. You were then observed pushing a bystander, attempting to calm you down. You were combative during the Ansonia police officers' attempt to place you in handcuffs, throwing your body into officers and attempting to pull away. You refused to get in the police car, becoming dead weight and eventually sitting on the ground. When the ambulance arrived, you continued to act in an aggressive manner by pulling away from officers and medical personnel. You were subsequently charged by Ansonia Ansonia Police Department with 53A-181, breach of peace, 53A-167A, interfering with an officer, and 53A-107, criminal trespassing first degree. Due to this, you're in violation of your parole and community service conditions, obey all laws, obedience to the law. In addition, the Parole and Community Services have submitted they also submitted 2 previous violation notices. Those are exhibits. I'm gonna add those to the exhibits. But in addition, they have also provided an addendum that they submitted on November 6th, 2024. And it states that on November 5th, 2024, Mr. Dukes, inmate number 347617, appeared in Derby GA5 under docket number A05D, CR 24-0193565S for the charges of 53A-181 breach of peace, in which he pled guilty and received unconditional discharge. The charge of 53A-167A, interfering with an officer, and 53A-107, criminal trespassing first degree, were subsequently dismissed. I also want to identify for the record the exhibits that have been filed by Parole and Community Services, and that's Exhibit A, the Connecticut Romantic Custody, Exhibit B, the Connecticut Signed Conditions of Parole, Exhibit C, the Notice of Parole Violation, Parolee Rights, Exhibit D, the Parole Violation Report, Exhibit E, the State of Connecticut Judicial Branch Documents, Exhibit F, Police Reports, and Exhibit G, the Summons. And that's where Exhibit H comes in also, the 2 previous parole violation notices. Mr. Dukes and Attorney Johnson, did you both receive the notice of parole violation, the parole violation reports, and all the other documents that have been marked for identification purposes?
Yes.
Yes, I did. And based on my recollection, my client, when he pled under the Alfred Doctrine in light of the fact that he was under parole. I asked that you weigh that because at the second phase of the hearing, my argument will be arguing for the least restrictive sanction on behalf of my client to have him be brought back into the community. But I do have some questions for him down the line.
Okay, great. Yeah, so I just want to make note, I have not received any documents from you at this time, correct, Attorney Johnson?
No, we're going to just have my client testify under oath.
Okay, no problem. So then as of today, we do not have any witnesses. So now it is your time, Attorney Johnson, to call any witnesses, present evidence, and speak to the charges of the evidence submitted.
Right. So, Mr. Dukes, at this particular time, when this incident occurred, is it fair to say that you didn't agree to all the facts of this particular case, but the fact that you were on parole, you wanted to resolve this issue, correct?
Yes.
And is it fair to say at the time you were charged with 3 different charges, interfering with a police officer, which is a Class A misdemeanor? In that case, that charge was dismissed, correct?
Yes.
And you were also charged with criminal trespass in the first degree, and that charge was dismissed, correct?
Yes.
And when you pled guilty on the what's called the Alfred Doctrine, which basically says you didn't agree to all the facts of the case, but you wanted to take advantage of the agreement where you receive an unconditional discharge, correct?
Yes.
And you didn't have to pay a fine or anything like that, correct?
No, I didn't.
Okay, I have no more questions.
Thank you. Okay, so I'm just going to take a moment to just review the evidence one more time, the testimony that was just given, and I will let you know of my finding.
How many times a day? All people come in and use that fly, use that.
May I continue and ask more questions in terms of, well, we'll probably go to the second phase. I'll wait till the second phase of it.
Yeah, the second phase is more for his background. If you have anything additional to say regarding the charge itself, by all means, please.
We already dealt with the charges.
Okay, all right. So for charge number one, I do find that you violated the condition of obedience to the law based on the conviction of the breach of peace, Connecticut General Statute 53A-181A on November 5th, 2024, when you pled guilty and was sentenced to unconditional discharge. In addition, the state did provide evidence to support the charge, and that's Exhibit B, D, E, F, and G. So now Attorney Johnson is the fact that concluded the fact-finding portion. Now is your opportunity to make a statement regarding your client's violation, his background, and his history.
Well, in terms of his background, I want to indicate that my client has consistently had a lawn care business. And since he's been incarcerated for the past 2 months, which in light of this particular incident, and he was charged with misdemeanors, his lawn care business is struggling and he lost his clientele. He did complete the domestic violence program, which I believe on the violation report, it indicates that that he has done that. And also, I think he's done 14 sessions. That demonstrates his growth and his rehabilitation. Now, I know there's an issue in terms of prior to violations, but if you go back, those 2 violations, I believe, were in 2021. If I'm not mistaken, 2021. If he's remanded back into custody, it's going to affect him in terms of his medication. He does suffer for some physical or mental health issues. Also, the fact that he's actively involved in his kid's life, and he's scheduled to have a DCF hearing regarding custody for his kids. I think he's employable. He has his own business, and he also has the opportunity to continue his employment. And I'm just waiting for the response from his employer, Mr. Belafonte, who's willing to give Mr. Dukes a job, as well as he has a living arrangement that he can, as soon as you release him, that he can live with Mr. Teese Johnson.
Thank you. Anything else at this time before I'm going to just review his record a little bit more, and then I will make my recommendation?
Well, I think that based on the overview of parole revocation hearing, one of the issues is, of course, the preponderance standard. But I think that in terms of your sanctions, I argue that in light of the factual allegations, what really happened, clearly this is a manifestation of him being intoxicated at the time. And a breach of peace is a specific intent crime. He had no intent of harming anyone. In fact, he was the one who actually was harmed. He ended up being taken to the hospital for injury. So I'm suggesting and urging that this parole officer place a sanction that's least restrictive and place him back into the community. I think he has shown that he can cooperate in terms of any prison time. He's been incarcerated for almost 2.5 months, and I think that's a reflective of time period of being incarcerated. And I just think that based on the 2 criminal charges that were dismissed, that were much more serious, interfering with a police officer, and criminal trespass, which are Class A misdemeanor, which are punishable up to 364 years in prison if you do it consecutively. You're talking about almost 2 years. Those charges were dismissed, and I ask that you weigh that in the totality of the circumstances, the fact that he has a history of compliance in terms of the program. He has done well, that you place him back in the community.
Okay, thank you. So I'm just gonna take a moment and I'll get back to you in a second with my recommendation.
Get up, go to the gym. I'm on the physical. Like home.
And
Yeah. You're low.
I'm bold up like me. On last year. I don't
Okay, so I have listened to the testimony today, and I also did review the evidence. And based on that, I am going to make a recommendation to revoke your parole, Mr. Dukes. And I'm going to also recommend that you serve a 6-month period of confinement as a sanction with a re-parole date of April 1st, 2025. And in addition to that recommendation, I'm going to recommend the following stipulations. So no alcoholic beverage consumption, behavioral management program for domestic violence, no contact with your co-defendants, Jarvis Lewis, Dawan Sloan, Michael Catchings, and Travis Snow, no contact with your victim, SMY, no contact with your victim, LW, without your parole officer's permission, a general no contact with BC and CBJ without your parole officer's permission, mental health evaluation, and no operation of a motor vehicle without your parole officer's permission. So that does conclude the hearing. My findings and the recommendation are going to be given to the board on December 12th, 2024, and you'll receive a written notice from them after. At that hearing, they can lessen my recommendation, they can let my recommendation stand, or if they want to impose a sanction longer than the recommendation, there'll be a supplemental hearing that you'll be notified and you'll be present for to address the concerns that they have, okay? Do you have any questions at this moment?
Officer Truscello, I have a question. Can you do a articulation why the 6 months as opposed to having him released? In fact, that he's been already incarcerated for 2.5 months.
I mean, I can give it will be in the report. This is his 3rd violation, a criminal violation. He was only in the community for 6 months at the time of this violation. So everything's kind of weighed into that, and the report will be sent to your office as well. So it'll provide additional details as to why the sanction was imposed. But that is my final recommendation for today. And it's up to the board. The board will see this on the 12th and they will make their decision. But that is just my recommendation to them.
Okay. Thank you.
Okay. Thank you. Take care. This concludes the revocation hearing, and I'm now going off the record. Hello, how are you today?
All right, good morning.
Good morning.
Good. They just shut the compound down for a few minutes, so it might take him a little while before he gets down here.
Okay, no problem. It's
Okay?
just the one, right? Santiago?
Yes. Yes.
Perfect. All right,
Okay.
sounds good. Thank you.
All right. Yes, sir. Go. Santiago. Oh, that's you? I can't see so far no more, man. How you doing? Leave your jacket over here. Good, good.
I'm on violation of parole. I just got back. Been out looking over 6 years. They still have they got me, man. They got me back.
Hi, Mr. Santiago.
Hello, good morning.
Hi, perfect. Good morning. Are you ready to start?
Yeah, well, I got a couple of questions.
All right, so I'm going to go through a long speech. I just need to swear you in first, and then we can get to your questions, okay?
Gotcha.
All right, cool. So I am Parole Officer Truscello. I'm a hearing examiner for the Board of Pardons and Paroles. And this is a preliminary hearing concerning Manuel, is it Manuel?
Yes.
Manuel Santiago, inmate number 267008. Today is Tuesday, December 3rd, 2024, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Carl Robinson Correctional Institution. Can you please state your full name and inmate number for the record?
Manuel Santiago, 267008.
Thank you. This is a public hearing and public has access to this hearing via video live stream. So this is your preliminary hearing and it has 3 purposes under the Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violates the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. And if I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. And please note that you have been referred to the Department of Corrections for a diversion for substance abuse programming and treatment. So if by the end of this hearing, I determine that you should be held in prison pending further proceedings, I'll provide additional information about the diversion program. You should know that this hearing is an adversarial proceeding and anything you say can be used against you, and this hearing is being recorded. In addition, the testimony at today's hearing is going to be taken under oath. So Mr. Santiago, can you please raise your right hand? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you. So I'm going to go over your rights. Well, I'm going to tell you the procedure for today's hearing. First, we'll go over your rights. Then we're going to review the parole violation that your parole officer has brought against you. I'm going to review and identify the exhibits that they filed for the record. The state is not present at today's proceedings, but you will have an opportunity to address probable cause and the severity of the allegations if you choose to do so. At the conclusion of the hearing, I will inform you of my findings, which will be based on the evidence. And that's pretty much it for today. Now's a chance. Do you have any questions about today's proceedings?
Yes, I'm confused, totally confused. This is my first time on parole, period,
Okay.
special parole, any parole. I've been on probation before. So this is crazy because I was actually speaking to the counselor about my paperwork. Someone brought me the paperwork last week and I told them I'm lost because from my understanding, what I got was I was being, my parole was being revoked because of my dirty urines and stuff, and I was being put on the TOP program, the TOP program.
Yep.
And that was, from my understanding, that was my sanction, the TOP program. So then I got the paperwork with what you were just talking about with everything and the records and stuff. And someone else, jail lawyers, so I had to ask around to see, but the jail lawyers were like, hold up, something's not right. Because from my understanding, my parole officer, Gerard and Stickles, when they brought me to Harford County, basically explained to me that all I had to do was the TOP program, and I'll be out in 45 to 60 days. That's why I waived the right to a hearing, because I got the dirty urines, I admit to it. I don't need, I'm not gonna sit here and deny any.
Okay, we're gonna go through all of that. Again, this is an adversarial hearing, so things can be held against you. But so let me just jump in quickly. So yes, Parole and Community Services, your officers have asked for you to participate in the diversion program, which is TOP, timeout. We just have to go through this proceeding because as a parolee, you have due process rights. So we have to make sure, or what today's hearing is I reviewed all the evidence as well to make sure everything's in line, that you did violate it, and that if you did violate your parole, I will let you know, because sometimes things happen and it can go either way. But also, like, if I do make a finding at today's hearing, I will then check your eligibility for the top program as well. So there's a few guidelines to it. They took the short way out by just saying you're going to do top. There's just a process. So this is the process. So I have reviewed all the evidence. We're going to go through that part. We do have to go over the rights that you have at this hearing. If you don't mind us moving forward with it, it might explain a little bit more as we go through it. It's kind of just procedure for you to be accepted into top if I find probable cause to the charges against you. Okay, does that make sense? All right, so I'm going to move forward a little bit. If you need to stop me, okay? So
Perfect.
you do have rights to this hearing. So your first right is that you have a right to be represented by an attorney. You may hire your own attorney, and if you cannot afford an attorney, you can ask for an appointed attorney to represent you. Were you informed that an attorney could represent you at today's hearing?
I was.
Are you interested in obtaining representation for your preliminary hearing?
I'm still confused. I guess at the end, I'll let you know, because I just don't want to make it harder for me or yourself to keep going through this. If I can nip it in the bud by just admitting what I did, you know what I mean?
So
I don't want to put everybody through everything. I was
going to say that you kind of already admitted to what you did. So like that,
right.
An attorney was here to represent you, right? Just to give you guidance for it. Unfortunately, you stayed on the record that you did it. So it's your right though. If you want an attorney, we can continue this. We can have you send an application to the public defender's office. They would meet with you. They would do a phone conference the next week or two with you to go over the charges, stuff like that, to come back and speak with me again to discuss the charges against you.
Like I said, I know I'm under oath, and the truth is the truth. I violated. I had dirty urines. There's no way, there's no ifs, ands, or buts. I'm not going to make any excuses.
Okay. So we'll move forward today. So just one more time to confirm, you're okay with moving forward in today's hearing without legal representation, correct?
I did. Did I answer that at the end of the conversation after you say everything?
Well, once we say everything, it's all done, unfortunately. So right now is your chance if you want it or not.
I don't want to prolong it any longer if we don't. I am honestly, like I said, I'm lost, totally lost. Don't know about the stuff. I don't know if I should continue with it or.
Well, I just don't want to violate your rights. So your biggest right is you have the right to representation. So you have to decide. Thank you, Attorney Jones.
Yeah, if I may, is this Mr. Santiago?
It is.
It is.
Okay, Mr. Santiago, I'm Attorney Sonia Jones from the Public Defender's Office. Is it your intention to participate in the timeout program?
It is.
Yeah, so I would advise you that you don't need to continue the case. If you're willing to participate in the program and you're determined to be eligible, you should just go along and be placed in the program as long as that's what you want to do. That's all our office would do for you, is we would also agree that you should be placed in the program and assist you with this hearing. But if that's what you want, you can handle that yourself. And my recommendation would be that you just go forward. There's no reason to delay it.
I don't want to waste anyone's time.
Okay. All right. Good luck, sir.
Thank you, Attorney Jones. All right, then, Mr. Santiago, we're going to keep moving forward then, okay? So you do have the right to receive written notice, and you mentioned that you received all the documents last week, correct?
Correct.
Perfect. You have the right to review that evidence against you before this hearing, and you also have the right to submit evidence in support of your case. You also have the right to call any witnesses and to cross-examine any adverse witnesses. Do you understand these rights, and are you ready to go forward?
I do, and I am.
So we're going to review the charges now that the state, your parole officer is bringing against you, and the underlying information for each charge. So on charge number 1, condition of obedience to the law, the charging officer reported that on August 6, 2024, you received an infraction from Hartford Police Department for failure to obey traffic signals and vehicle prohibited on sidewalks. On charge number 2, condition of drugs, the charging officer reported that on 5/17/24 you used cocaine, on or around 5/21/24 you used cocaine and heroin, on 6/9/24 you used cocaine, on 8/14/24 you used cocaine, on or around 8/20/24 you used cocaine, heroin, and opiates, on 11/9/24 you used cocaine, and on 11/12/24 you used cocaine. On charge number 3, condition of no consumption of alcoholic beverages, the charging officer reported that on 5/28/24 you used alcohol, on 6/9/24 you used alcohol, on around 9/4/24 you used alcohol, on 11/9/24 you used alcohol, and on 11/12/24 you used alcohol. In addition, the state has filed the following exhibits that have been pre-marked for identification purposes, and that's Exhibit A, the notice of parole violation, Exhibit B, the notice of parolee rights, Exhibit C, remand to actual custody order, Exhibit D, the PCS signed conditions, Exhibit E, the halfway house agreement, Exhibit F, the voluntary drug admission, Exhibit G, the Premier Biotech Technologies lab report, Exhibit H, the offender misconduct, Exhibit I, the voluntary drug admission, Exhibit J, the offender misconduct, Exhibit K, the voluntary drug admission, Exhibit L, the offender misconduct, Exhibit M, the offender misconduct, Exhibit N, the Department of Motor Vehicle Driving ticket, Exhibit O, the voluntary drug admission, Exhibit P, the offender misconduct, Exhibit Q, the Premier Biotech Toxicology lab reports, Exhibit R, the voluntary drug admission, Exhibit S, the offender misconduct, Exhibit T, the voluntary drug admission, Exhibit U, the parole violation report. And that is all. Again, just to confirm, Mr. Santiago, you did receive all of those exhibits that have been pre-marked and identified for the record, correct?
Correct.
Great. I have not received any documents from you. Is that accurate?
Correct.
And we do not have any witnesses today. So at this time, it is your opportunity to respond to the parole violation charges against you. However, you may remain silent if you choose to do so. So would you like to make any comments in regards to the charges that your parole officer has brought against you?
No.
And just to reiterate, I am making note that you did admit that you did the violation, correct? You said that twice earlier in this hearing, so I am just going to make a note of that for the record, okay?
Correct.
Okay. So at this time, I'm just going to take a moment and then I will let you know of my findings quickly. So for charge number 1, condition of obedience to the law, I'm going to make a no finding of probable cause based on the information reviewed for this preliminary hearing. Both the failure to obey a traffic signal and vehicle prohibited on a sidewalk, they're not crimes, they're infractions. So I'm making a no finding for charge number 1. For charge number 2, I have identified this charge as 7 separate parts for each date that they have charged you for. So for part 1, dated May 17th, 24, part 2 of 5/21/24, part 3 of 6/9/24, part 4 is August 14th, 24, and part 5 is August 20th, 2024. I'm making a no finding of probable cause based on the evidence submitted and the information received for this hearing. I am making a finding of probable cause for part 6 with the charge date of November 9th. November 9th, 2024, and part 7 with the charge date of November 12th, 2024, based on the evidence that has been submitted, which is Exhibit D, T, and U. And for charge number 3, no consumption of alcoholic beverages, I've identified this charge as 5 separate parts. So for each date associated with the charge. So for part 1, dated May 28th, 2024, part 2 of June 9th, 2024, and part 3 of September 4th, 2024, I'm making a no finding of probable cause based on the evidence submitted and the information reviewed for this hearing. I am making a finding of probable cause for part 4 with the charge date of November 9th, 2024 and November 12th, 2024, based on the evidence that has been submitted. And that's Exhibit D, T, and U. So at this time, I do find that the acts are serious enough to warrant revocation, and I've also determined that you should be detained while you await your revocation hearing. And the Records Department will be notified. However, the Department of Corrections, which is Parole and Community Services, has recommended that you for you to participate in the diversion program. You can't hear me? No? It's making noise? Ms. Benedict, what do you think? Oh, no.
Can you hear me? No,
I
was
can hear
making
you
a noise.
now.
It went out.
Oh, I can hear you. I just can't see you guys now.
It went out for a minute, Gio.
Yeah, sometimes
It was making a noise.
How about now?
I can hear you and see you.
You can see me? I can't see you.
He's working on it right now.
Okay.
It went totally blank when you were gonna speak, so I did not hear anything of the last part of
You
your
didn't hear-
findings.
You didn't hear any of the findings? Oh, boy.
No, not the whole, your decision.
Can you see us?
Okay, so you heard the findings part. So we'll start
Yeah.
at moving on to the diversion program portion.
No, you can't
Officer,
see it 'cause
Officer, is your
I
camera
don't
turned
know
on
why
at the
that
moment
is.
at Robinson?
I could reboot it and see.
If you just look down at the tablet, do you see the camera icon?
The camera, hold on. There
you go.
We
Awesome.
see you now, but can you see us again?
Yes,
Perfect. All right,
I
Mr.
can't see you,
Santiago.
Ms. Jones. I can see you, not Ms. Jones.
Truscello, you
Okay,
can see me?
yes,
Miss
Perfect.
Jones's camera is off, so you shouldn't
Yeah.
be able to see her.
okay.
Okay, so.
I gotta
where
get a
did-
little closer. It's a little, the volume went down a little bit.
Okay,
Okay.
what did you last hear? Did you hear the findings for everything? And what, did you hear that I'm going to let your records department know in the facility? Did you hear that part?
Yeah,
You heard that, you heard all that, so that I
I
did
heard
make a finding?
everything. I heard all of the
The
findings, all of
findings?
the, yes.
All right, so we're gonna move on to the, that Parole and Community Services has recommended for you to participate in the diversion program to receive substance abuse programming and treatment. And what that is that if you wish to participate and apply, and I find that you meet the criteria, I will continue your case while you are provided an opportunity to participate in the program at Carl Robinson. And then if you successfully complete the program and treatment provided, I will dismiss your case and order for your parole to be reinstated. If you do not complete the program and treatment provided, the board will schedule a revocation hearing to determine if you violated the conditions of your parole. And at that time, a hearing examiner will make a recommendation regarding whether your parole should be revoked or not. Do you understand all of that?
Okay, so I am doing the top program. As of now, I just got moved to the top program yesterday. I started, yesterday was my
Perfect.
first day there. So I have already enrolled.
So we're just gonna go through the criteria. I'm gonna admit you into it for the record, for the legality of it. And I'm going to accept you. So once that happens, you'll just participate in that program. As long as you successfully complete that program, you will not see us. You'll be released at the completion of that program. You'll be back on supervision with your parole officer, okay? What that said though is if you do not successfully complete it, we will schedule a revocation hearing for you to discuss the revoking your parole at that point, okay? Make sense?
Gotcha.
Cool, so I'm gonna
Yes.
keep going a little bit further. So you do wish to apply for the diversion program, correct?
The top program, right?
Yep.
Yes. Yes.
So I am going to announce my findings with respect to your eligibility. So I do find that you have no pending misdemeanors or felonies. I find that your discharge date is more than 60 days from the date of your remand to custody. I find that there is evidence that you have identified substance abuse treatment needs. I also find that substance abuse is reasonably considered to be a motivating factor in your alleged failures to comply with the conditions of your parole. And I also find that there's evidence that you were provided with opportunities to receive substance abuse programming and treatment during the period of parole supervision in the community. So at this time, I am determining that you are eligible for the diversion program for substance abuse treatment. I'm going to accept your application into the diversion, and I ask that you indicate whether you understand the following answers with a yes or no. So the first one is, I understand that I will remain incarcerated while I receive programming and treatment, and that parole revocation proceedings may be delayed as a result.
Yes.
I understand that the dismissal of my case and reinstatement to activate parole supervision is not guaranteed and is conditioned upon my successful completion of substance abuse programming and treatment.
Yes.
I understand that ultimately the Department of Corrections will determine whether I have successfully completed the substance abuse programming and treatment provided.
Yes.
And lastly, I understand that my participation in this process is completely voluntary.
Yes.
Perfect. So your application is granted for the diversion program, which is the top program. You will be placed in the treatment provided by DOC, which you said you already moved into. So it sounds like you're in the process of getting it started, and diverted from revocation for no more than 60 business days. Okay. So once you complete it, we'll be notified by your parole officer in the community and you'll go back on supervision. Okay. As long as it's completed successfully. All right.
Yes.
Any questions at this time, Mr. Santiago?
No.
Then you are all set. Thank you for speaking with me, and this concludes your preliminary hearing.
Thank
You
you.
have a great day. Good luck with everything, Mr. Santiago.
Thank you so much. Appreciate you.
Okay.
Ms. Benedict, if I just hit this end button, this red phone, it's going to hang up with Robinson, correct?
No, that will hang up your room, but I can remove Robinson.
Please do, and then we'll do a training session, okay? Thank you. Hello.
Hi, how are you?
Great, how are you?
Good.
Can we start with Mr. Morales, please?
Yes.
Thank you.
You're welcome, around.
Yeah.
I'm trying to call this officer. He wants to participate. Hi, Mr. Morales. You can have a seat, please.
How you doing?
Great, how are you?
All right.
Good morning, Mr. Morales.
Good morning.
Know his name. Hi, is this Officer Barstow?
Hey, good morning.
Good morning, thank you. All right, so we are going to get started now. I am Parole Officer Truscello, and I'm a hearing examiner for the Board of, there's a lot of noise.
What,
Is that
on my
coming
end?
from? Yeah, I feel like, right, Ms. Benedict, that's coming from Mr. Barstow? Yeah.
Yeah, Mr.
just-
Officer Barstow, are you watching the hearing in the background as well?
No.
Okay, we're just getting some
No.
ambient noise coming through.
Okay, all right. I'm gonna turn off this heater we have here. Maybe that's it.
Okay, sorry, thank you.
That's okay.
All right.
All right, is that better?
Yeah, it seems like it. Thank you. Okay, so I am Parole Officer Truscello. I'm a hearing examiner for the Board of Pardons and Paroles. And this is a preliminary hearing concerning David Morales, inmate number 087628. Today is Tuesday, December 3rd, 2024, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office and Osborn Correctional Institution. Mr. Morales, can you please state your full name and DOC inmate number for the record?
David Morales, 87628.
Thank you. This is a public hearing and public access to this hearing is available via video live stream. And present this morning is Attorney Jones and Parole Officer Barcel. Attorney Jones, can you please identify yourself for the record?
Yes, thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit on behalf of Mr. Morales.
Thank you. And Officer Barcel, can you please identify yourself for the record?
Yep, good morning, Parole Officer Barstow, Special Management Unit, New Haven and Bridgeport.
Thank you. This is a preliminary hearing, which has three purposes under Connecticut law. The first is to determine if there is probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. And if I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. Sorry. If I find probable cause and determine that the act is sufficiently serious to warrant a revocation, you may be held in prison pending further proceedings. You should know that the preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. And this hearing is also being recorded. Is this a top?
Yeah.
It is a top.
Yep.
Sorry, I'm really confusing myself. I'm going to go backwards. So if I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings, but please note you have been referred by the Department of Correction for diversion for substance abuse programming and treatment. And if by the end of this hearing, I determine that you should be held in prison pending further proceedings, I'll provide additional information about the diversion process. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can't be used against you, and this hearing is being recorded. The testimony at today's hearing will be taken under oath. So Mr. Morales and Officer Barstow, can you both please raise your right hand?
I'm not sure.
Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, to help you God or upon penalty of perjury?
Yes. Yes.
Yes.
Perfect.
Yes.
So we're going to go over the procedure for the hearing. The first is that I will read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. Then I'll review and identify the exhibits filed for the record. The state will then have an opportunity to address the issue of probable cause and the severity of the allegations. And after the state is finished, you will have the same opportunity. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
No.
You have important rights for this hearing, and I'm going to review them with you now. You have the right to be represented by an attorney at this hearing, and counsel is present for you. You have the right to receive written notice of the charges of violation. Did you receive the written notice?
Yes.
Yes, okay. You have the right to review the evidence against you before this hearing, and you have the right to submit evidence in support of your case. And you also have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
Okay. So right now we're going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. Officer Barstow, can you please read the charges that you have brought against Mr. Morales, starting with charge number 1, condition of drugs?
If I may interrupt, I apologize. My client is electing to waive the first portion of the hearing and concede to probable cause and would like to go forward with the eligibility portion.
Okay. Never mind. Thank you, Attorney Jones.
You're welcome.
Okay. All right. So then at this time, as you have waived probable cause, we will move forward. So the Department of Corrections has recommended you, Mr. Morales, for the diversion from the revocation process for substance abuse programming and treatment. And that means that if you wish to participate and apply, and I find that you meet the eligible criteria, we will continue your case. And that way you're provided the opportunity to participate in that substance abuse programming in the correctional facility. If you successfully complete the program and treatment provided, I will then dismiss your case and order your parole reinstated. If you do not complete the programs and treatment provided, the board will then schedule a revocation hearing to determine if you violated the conditions of your parole. And at that time, if that does take place, the hearing examiner will make a recommendation regarding whether your parole should be revoked and if any sanctions should be recommended. The decision to participate in the diversion program is voluntary. Do you understand that the diversion process? Do you understand the diversion process, and are you ready to apply?
Yes.
Okay. Yeah.
I just don't know if you need to place the evidence on the record.
Oh. Okay. We can.
That you might still. I'm not sure.
I don't.
Okay, so
That's all.
we're gonna
That's
go
all.
backwards.
I know.
Yeah,
I apologize. And I apologize. I apologize.
Okay, you threw me off a little. All right, so we'll go back. So we're just gonna identify the evidence that Parole and Community Services had submitted in support of this hearing. Officer Bruslow, can you please identify the exhibits you have submitted for the record?
Yep, hold on a sec.
No problem.
Give me 1 sec, please.
No problem. Take your time. If you don't have it, I can go over it for you.
Yeah, that'd be great. I'm having trouble with case notes right now.
Yeah,
I'm actually.
I hear you. It hasn't been loading at all for me. So yeah, so I will go over it now. So for evidence submitted, it's Exhibit A, the remand to custody. Exhibit B, the parole agreement. Exhibit C, the halfway house agreement. Exhibit D, the Roger Sherman halfway house email correspondence dated September 7, 2024. Exhibit E, the misconduct dated 9/10/24. Exhibit F, the Quest lab results dated 9/13/24. Exhibit G, the positive urine report date 9/18/24. Exhibit H, the misconduct date 9/19/24. Exhibit I, the misconduct date 9/25/24. Exhibit J, the voluntary admission dated 9/25/24. Exhibit K, the misconduct dated 9/30/24. Exhibit L, the Roger Sherman halfway house incident report dated 9/30/24. Exhibit M, the misconduct dated 11/6/24. Exhibit N, the Roger Sherman halfway house incident report dated 11/6/24. Exhibit O, the misconduct dated 11/8/24. Exhibit P, the Roger Sherman halfway house incident report dated 11/8/24. Exhibit Q, the misconduct dated 11/9/24. Exhibit R, the Roger Sherman halfway house email correspondence dated 11/9/24. Exhibit S, the notice of parole violation. Exhibit T, the Roger Sherman house resident handbook. And Exhibit U, the parole violation report. Attorney Jones, just to confirm, you and your client both received all of the evidence and notices?
Yes, thank you.
So to go over again, we waived the probable cause. So Mr. Morales, do you wish to apply for the diversion program?
What's that, treatment program?
Yeah, the top program.
Yes, ma'am.
Okay, so we're gonna go over some information now. So I'm gonna announce my findings with respect to your eligibility. And if I determine that you are eligible, I will accept your application and divert you from the revocation. Do you have anything to add at this moment?
I want to, apologize to these people. I was wrong.
I got caught up in something that I didn't want to do, was start using drugs. It was all around me in there. That's not an excuse, you know, I felt weak. You know, and, my parole officer, you know, he's a good guy. He was working with me, helping me, you know, and you know, he treated me fair, you know, and I apologize to him too, and to the board, and, you know, and, you know, I got time to get back on track, you know, to clean up my act. So whatever help, you know, I will accept it and, you know, go back to the I Foundation, because I found that helpful, you know, trying to get some help, because I want to, you know, I want to stay clean, you know.
Yeah.
And you know, and I'm you know, I'm willing to participate and, you know, give this another shot. You know, I'm older, you know, I'm trying to get my life in a place to live and become, you know, like someday probably go back to work, you know, in the future. That's my goals, you know. And, you know, I apologize, like I said, you know, to everybody, you know, even my family, you know, I just feel, you know, I feel ashamed and embarrassed, you know, that, because I said, you know, like on my mother's graveside, I promise I will never pick up, and you know, I didn't see this coming, you know, I just, you know, I felt weak at a time when I was stressing, you know, I was waiting to go to see doctors, you know, to get some mental health stuff, you know, counseling, and that's what I'm still trying to do, you know, get the mental health psychiatrist, you know, meet up with him and get some antidepressant medication and
Okay, Mr. Morales, so it sounds like you're ready to accept the help, correct?
Yes, I am.
Thank you for your comments, David.
Yeah, so I am gonna, so I'm gonna just review the eligibility. I find that you have no pending misdemeanor or felony charges. I do find that your discharge date is more than 60 business days from the date of your remand to actual custody. I find that there is evidence that you have identified substance abuse treatment needs. I also find that substance abuse is reasonably considered to be the motivating factor in your alleged failure to comply with the terms and conditions of your parole. And I find that there is some evidence that you were provided with the opportunity to receive substance abuse programming and treatment during your period of parole supervision in the community. So at this time, I am determining that you are eligible for the diversion for substance abuse programming and treatment. And before I accept your application for diversion, I ask that you indicate whether you understand the following by answering yes or no. I understand that. Okay, I'm going to read 4 statements. I just need you to respond to them, okay? So the first one is, I understand that I will remain incarcerated while I receive programming and treatment, and that parole revocation proceedings may be delayed as a result.
Yes.
I understand that the dismissal of my case and reinstatement to active parole supervision is not guaranteed and is conditioned upon my successful completion of substance abuse programming and treatment.
Yes.
I understand that ultimately the Department of Corrections will determine whether I have successfully completed the substance abuse programming and treatment provided.
Yes.
And lastly, I understand that my participation in this process is completely voluntary.
Yes.
Perfect. So your application for the diversion is granted, Mr. Morales. You'll be placed in treatment or programming by the Department of Corrections and diverted from revocation for no more than 60 business days. All right, so you'll be starting top soon if you haven't started already, okay, Mr. Morales?
Yeah, I started the lady interview. I just don't have a date, you know, like, because I've been trying to get a date. They give me all wrong dates.
That's okay. Your officer, Barcel, will be notified by them when you're completed, and he'll be sending us the information, okay? So just
yeah,
worry
but they don't have a date
and
the date for the 45 days. So I can just at least have a date, so from the start to the end.
Yeah, you'd have to ask the counselor in the top
Yeah,
program.
I did.
Ask them again.
I did.
Yeah,
they gave me some wrong information. This past 45 days, they gave me wrong information.
Okay, we'll try again, and if not, maybe see if there's a counselor supervisor you can ask, because they're the ones who will notify Officer Barstool of your completion, okay?
All right, and I go back to the New Haven, not to Roger Sherman, the other one, my parole, is there a way for me to find out? Because I don't want to go back to the same facility, because there's too much drugs in there. I will prefer to be moved to the one on Howard Avenue, if that is possible.
So Officer Barstool and Parole and Community Services are responsible for housing. Did you hear that, Officer?
Yep. And we discussed this before that, unfortunately it really comes down to where we have bed space, but we'll do our best to try to accommodate him getting back to New Haven.
Okay, so he'll work with you
Yeah,
when
the
it's time
Howard
for you to be
Avenue,
released.
the one at Howard Avenue,
Yep, I hear you.
the halfway house.
Yeah, Ms. Morales, you should focus on that program, okay?
Yeah, I'm gonna do that.
If I can lastly just clarify for the record, since the defense did concede probable cause, you are making a finding that it's serious enough to warrant, serious enough that he should be detained.
Correct, I am making a finding that it's serious enough, and the records department will know that as well.
Okay, all right.
All right, we're all
Thank
set
you.
then. Thank you, Ms. Morales, good luck.
All right, good luck, Mr. Morales, okay? If you have any
All right,
issues,
so
please
I
feel
gotta
free to
just do
contact our
I
office.
gotta do a program 2 months. How much? 45 days? I have problems with it.
Correct, that's correct.
45-day program,
Yeah.
that's what I'm doing. All right.
Yeah, okay, if you want to contact my office, I'm happy to count the dates out on the calendar for you.
They don't let me, like I put in for phone calls, I was trying to call for Social Security because I get disability, for 2 head injuries,
Okay.
and I forget a lot of stuff, I even forget to take my meds in here, and I've been struggling with that, and I have,
Yeah.
short, long-term memory loss.
Yeah, if you just tell your counselor that you would like a legal call, he will email me to schedule the call, and I'm happy to count the days out for you so you know exactly the date, okay?
Yeah.
Okay.
All right,
Thank
thank
you,
you.
everybody.
All right, good luck, sir.
Like I said, I apologize again, I'm sorry for my
Thank
action,
you.
and I regret, everything, not just that call, but I was, I was going through a lot, I lost my mother and a family members passed away. And I was dealing with that, and I don't know how to deal with that, especially with that.
I think everyone understands that. So good luck in the program, sir, okay?
Good luck.
All right,
Focus on
thank
that
you.
program. Take
Okay.
care.
All right,
This
I see
concludes
you.
the preliminary hearing.
So the parole's gonna come get me, right?
Yes, all right.
All right.
All right, Ms.
All right,
Morales,
thank
good
you.
luck. Focus on the program, okay? Good luck
Okay.
with everything. This
All
concludes
right,
the
thank you.
preliminary hearing.
All right.
All right,
For
thank
Ms.
you.
Morales. Thank you, you're all
Thank you.
set.
All right. All right.
Thank you, Officer Barstow.
Thank you.
All right, thank you, everyone.
Bye-bye.
Howard? No, you can go back to the library, I believe.
Good morning.
Good morning. Mr. Howard. Attorney Jones left. 1 second, I don't think the PO. I'll be right with you, Mr. Howard.
That's okay, take your time.
All right, so I am Parole Officer Truscello, and I'm a hearing examiner for the Board of Pardons and Paroles, and this is a preliminary hearing concerning Christopher Howard, inmate number 339747. Today is Tuesday, December 3rd, 2024, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Osborn Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Christopher Howard, number 339747.
Thank you. This is a public hearing, and public access to this hearing is available via video live stream. So this is a preliminary hearing which has 3 purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe that you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you, and this hearing is being recorded. So today's testimony will be taken under oath. So can you please raise your right hand? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you. So you do have, we're going to go over the procedure for the hearing, and then we'll go over your rights. So the procedure is that I will read you your rights first. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to address the issue of probable cause and the severity of the allegations. And at the conclusion of the hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
I do not.
Okay, so you do have important rights for this hearing. And the first one is that you have a right to be represented by an attorney at this hearing. And you may hire your own attorney. And if you cannot afford an attorney, you may qualify for an appointed attorney to represent you. At this time, I received notice from the public defender's office that they have been trying to schedule a legal call with you. Does that sound accurate?
I haven't heard anything about it, and I've been in jail, 2 weeks? I've heard nothing. Osborn does everything they can really to keep us from getting legal calls. Like everything they do, the counselors are never in the block. This jail is bad.
Yeah, so they from what this says, they've been emailing to schedule the call.
Because usually Sonia Jones contacts you immediately. She's very good.
She's very good. Absolutely, I agree. So at this moment, Mr. Howard, would you like a continuance to obtain representation?
I mean, I don't want to. I would like Sonia Jones. She's always been really good.
Okay, so what would happen?
She's usually who they give me.
We can continue your case today. My next hearing is December 17th. That would give enough time for, I don't know if it would be Ms. Jones, but it's her office, the public defender's office. Someone from there can work on getting that legal call to you to go over this if you would like that to happen.
It's almost unlikely that they're going to get a legal call here. It's like the counselors here, legit, we have a counselor come in at like 2 in the afternoon when Sonia Jones is already gone. Like they expect everyone to work around him. I don't know why they put me here. I was supposed to go back to Cheshire. They didn't. Like everything is a mess. Like,
yeah, it doesn't sound like it's ideal at all. I can't do anything about staffing up there. I can give the case more time if you would like to speak with her.
how severe is it that I need her now instead of just like if we proceed with this and then would I still be given an attorney?
So if you wanted to proceed today and the case moves forward to a revocation, you can ask to obtain an attorney for the revocation hearing as well.
And it'd still be through the public defender thing.
It sounds like that they've been trying to work with you. Yeah, so it would be through their office. I can't give you legal advice as to moving forward today with or without representation. That's 100% up to you.
No, I was just asking.
Yeah, and like I said, we can continue it. My next hearing is December 17th for you to speak with someone before the preliminary hearing.
Continuing. We can continue.
You want to give it a try? Okay, so we'll continue your case to December 17th for you to make contact.
No. I said we can continue with the hearing.
Oh, you want to move forward with the hearing
Yeah, there's
without
no
representation?
charges or anything.
Okay, as long as you're sure. So I'm going to keep going. I'm probably going to ask you 3 more times. If you want an attorney, just deal with me. Okay?
I don't want to make it a headache for you, so it seems like it would be easier to just move forward.
Well, this
get
is
it
your
out the way
hearing.
so you don't have to.
I want to make sure that you're represented how you want to be represented. And if that is giving you more time, whatever you choose to do, I will, like I said, ask you a few more times if you're okay with moving forward without counsel.
And I respect that, but for now, we can move forward.
Move forward, okay. All right, so then the next right you have is the right to receive the written notice of the charges of your violation. Did you receive that written notice?
Which thing is that? That's the one that's just charge 1, charge 2, charge 3, right?
Yes, yep, that's it.
Okay, yeah, I got those.
You received it? Okay, perfect. You also have the right to review all the evidence before this hearing, and you have the right to submit evidence in support of your case. You also have the right to call any witnesses and to cross-examine any adverse witnesses. Do you understand these rights, and are you still ready to move forward?
I understand them. Still ready.
So we're gonna move on to the charges that the state your parole officer has brought against you and the information underlying each charge. So for charge number 1, condition of GPS, the charging officer reported that on November 15th, 2024, you failed to properly charge your GPS unit, resulting in a device shutdown from 2:01 p.m. to 2:54 p.m. Your actions are in violation of your assigned GPS agreement, which states, I am responsible to ensure the GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the charging cable into an electrical outlet for at least 2 hours each day. On charge number 2, condition of drugs, the charging officer reported that on or around 11/14/24, you used cocaine, and on or around 11/15/24, you used cocaine and an opioid.
Oh, no.
Yeah, let me just go
And
through it,
that's-
and then you can talk on,
okay.
you'll be able to talk for each charge, absolutely. On charge number 3, condition of halfway house placement, the charging officer reported that on November 7, 2024, you were allowed an authorized drop off by Eddy Center Halfway House upon your arrival to the halfway house. During the drop off, you were extremely rude and were yelling at the drop off person to shut up. The interaction between you and the drop off person was so disruptive that halfway house staff had to intervene and end the drop off. Your actions are in violation of your signed halfway house agreement, which states I will treat others with respect and not engage in verbal or physical altercations with other offenders, staff, or third parties. On November 15, 2024, you were found in possession of a used crack pipe at Eddy Center Halfway House. Your actions are in violation of Eddy Center Halfway House rules, which prohibit the possession of drug paraphernalia and list such items as contraband. Eddy Center Residential Halfway Handbook Contraband List. In addition to the charges brought against you, the state has filed the following exhibits that have been pre-marked for identification purposes as Exhibit A, the remand to actual custody order, Exhibit B, the signed PCS conditions, Exhibit C, the notice of parole violation and parolee rights, Exhibit D, the parole violation report, Exhibit E, the halfway house agreement, Exhibit F, the GPS agreement, Exhibit G, the Eddy Center incident report, date 11/7/24.
Can I stop you for 1 second?
Sure.
They only gave me 3 charges on the paper. You read 4.
I read 3. The 3 charges, the two last ones I read were both under halfway house placement. So there's 3 charges total. Yeah, the date of November 7, 24 and November 15, 24 were both under halfway house. Okay. Exhibit I, the voluntary admission for use of cocaine on 11/14/24. Exhibit J, the Allied Universe Monitoring Report for 11/15/24. Exhibit K, the Eddy Center Incident Report dated 11/15/24. Exhibit L, the Middlesex Hospital After Visit Summary dated 11/15/24. Exhibit N, the picture of cocaine pipe found in subject's possession on 11/15/24. Exhibit N, the Eddy Center Residential Handbook and Contraband List. Exhibit O, the signed Eddy Center Residential Handbook Acknowledgement Form. So you did mention you received the notice, which has the charges on it, the violation reports, and did you receive all the other documents I just listed for identification purposes?
I haven't received like a photo evidence or anything like that.
You haven't received a packet of evidence?
They said there's a photo of a used crack pipe.
There's
They
one
said it's
photo,
found.
but the packet's like this big. Did you receive a packet like this?
I have not.
You have not. Would you like time for us to provide that evidence with you before moving forward?
It was pretty self-explanatory as to what there is. There was a
Okay, so-
used pipe.
Okay, so as long as you're
Up
willing
here.
to, again, still move forward today without seeing the evidence. Sorry, yes?
I told them admittedly, I didn't use I told them admittedly, I used cocaine. But the crack pipe they found was found in a hoodie. I wasn't wearing a hoodie. They said it was found in the singleton in the hospital told me it was found in the hoodie on a couch. I was not wearing a hoodie. I had a thermal and black pants. I don't smoke crack. I sniffed coke. It happened to be laced. I fell out. I know I was in the wrong. I have a drug problem. I've struggled with it for a long time. I'm not asking for it to be negated that I use drugs. No, I know that was wrong. but I didn't do it in a halfway house. I did it on my pass. I came back. I'm not dumb enough to bring it in a halfway house. That's my only thing. Like, that's not my pipe. They found it in a hoodie on a couch and they're saying it's mine.
So they found
I have
it
no
on
problem
the couch
giving
in
them
the
in
halfway house.
urine. I told them that I used cocaine. I admitted it. I didn't lie about it. I have a problem. I know I do.
So I'm making note of that so that you're admitting to that, but you're stating that the crack pipe that they're saying was found in your possession was in a hoodie on a couch that did not
It was
belong
found
to you?
on the couch. It wasn't in my pocket, nothing. I was wearing a thermal and my pajama pants ready to smoke a cigarette for the night. It just so happened the coke I used had something else in it. They said it was an opioid. I didn't get a paper that said exactly what it was. They just said opioid. I don't know what it was.
So like I said, I am gonna just note it for the record.
And I did also, when they were putting me in Middletown, because I knew Middletown, that specific halfway house, has problems with drugs being passed around in it, and it would be a temptation for me. I asked them not to put me there. They assured me it was temporary, only to tell me a week later that I was stuck there. It was a very stressful place for me. I screwed up. I'm not used to all the freedom in a halfway house where we just go out the door whenever we want to smoke. People smoking weed. I'm not used to that. And then no locks on the bathroom door was a stressor. I'm not used to all of that. And I'm not using it as an excuse. I'm just saying it was a stressor. I relapsed. I screwed up. 10 days for me is pathetic. Even me, I make 2 months usually. Before I start having trouble. I messed up.
But I am listening, I'm noting it. You're
I'm
just
not
one
lying and
concern.
saying that I didn't mess up.
No, but you're one.
I'm not lying and saying I didn't relapse. I'm saying that that's not my crack pipe. And I'm not gonna, like, I don't wanna be, I'm not a crackhead.
Again, I am
There
noting
was
all
something
this.
in it and it was bad.
So your one concern is that that crack pipe does not belong to you. It was not in your
The
possession.
crack pipe is
That's your-
not mine. You're telling me there's paraphernalia. There's no I sniff coke. I don't smoke crack. There's no way you found it in my possession. It wasn't in my pocket. The police searched me. There was nothing in my pocket. And now all of a sudden you're saying there's a hoodie in my property in DOC. I wasn't wearing a hoodie. You can look on the half-house camera. There was no hoodie on me. They went and got that hoodie and put it in my property. I was not wearing a hoodie. I came with no jacket, no shoes, just thin pajama pants and a black thermal.
All right, thank you,
I'm
Mr.
not
Howard.
saying I'm not a screw up. I screwed up more times than I can count. But I did put my best foot forward. When they gave me the timeout program before, I did my best and got through it, which I surprised myself. Usually I don't do that. But I asked them to put me in Waterbury because there's a lot more drug programs in Waterbury that I know of that can help, and they refused. They said it was an emergency placement. So Middletown was where it was. You got me walking a mile to find downtown.
Yeah.
I didn't know anything. For me, change is bad.
Yeah.
I've never been good with it. I didn't know anything. I didn't know anyone. It was, the halfway house was so open, like people in the backyard were smoking weed. They're talking about, oh, it's an unwritten rule, but they don't really care. But to me, that's hard on me because if I smoke weed, I'm gonna do something else. Then everyone's just moving around. It was so much of a stressor to be in that specific one. I fell
Sounds
apart.
like the environment wasn't ideal at the moment. Okay.
It wasn't ideal where I was mentally with my drug addiction.
Yeah.
I needed more of a closed area, like Waterbury, the halfway house is there. That's why I requested it. They're closed. You don't just go outside unsupervised. There's no freedom. The windows don't open where you get in and out
Yeah.
Like,
Yes.
it scared me and I freaked out. I'm not asking for you to say, oh, no, that's not what I'm saying. I'm saying, like, I have a serious drug problem and it wasn't, I asked them not to put me there. And if you look at it, Supervisor Mann, I believe his name is.
Yeah.
He was on the phone with me when they tried to pull me out of Cheshire and put me in Eddie Center. I was freaking out. I asked him to leave me in Cheshire.
Yeah.
Until they found the bed. And he'll attest to that. Rosario was the one driving me. She can tell you the same thing.
Not the ideal place for you. Yeah, so it sounds like you're aware of
I was
that.
freaking out. I didn't know anything. I knew I was gonna fall apart, but I was trying to put my best foot forward.
Yeah.
And then they gave me an infraction for saying shut up. I didn't say shut up like crazy. I wasn't yelling until the staff came in like, oh, you can't tell somebody shut. Like, come on. I wasn't like, I get it. It's not okay to be disrespectful.
Yeah.
But I think they went a bit much. I got slapped with a GPS just for saying shut up. Then it seemed like one thing after another after another.
Okay. So I have
And
listened
for
to you
long, it
today.
was so
and,
much that I couldn't
Yeah.
cope.
So
I had
Lisa,
no coping skills put into place, nothing.
this is your preliminary hearing. So it is just to determine probable cause, which is just a small standard threshold. So for today's purposes, I have listened to everything you said. I'm going to include it all in the summary. You will get a copy of the summary. I'm going to make a finding for your case at this point. And then after that, we will discuss what will happen next, okay? So for charge number 1, condition of GPS, I am making a finding of probable cause based on the exhibits B, D, F, and J. For charge number 2, condition of drugs, I am going to make a finding of probable cause based on exhibits B, D, I, K, and L. And for charge number 3, condition of halfway house placement, I am going to make a finding of probable cause based on exhibits B, D, E, G, H, K, N, O, I, and L. So those are my findings for today, and I do find that the acts are serious enough to warrant revocation. And I've also determined that you should be detained while you wait the revocation hearing. So the records facility, as well as your parole officer, will be notified. I'm going to make a note also that you would like representation for the revocation hearing, correct?
Yes, I would.
Okay. So I'll make note of
Now,
that.
you said I could inquire as to the severity of this.
So I'm making a finding that the actions are serious enough at this point.
Well, no,
move
you
on
said
to
I
the
could inquire
revocation.
as severity of the actual. How
Well, this-
severe is it
Well,
in terms of violations?
So at the preliminary hearing, it's just for the findings. So you made your statements for each charge that I've taken notice of, and I note it. At this time, I have made a finding of probable cause for just the preliminary process. The revocation hearing is when you speak upon the seriousness and what's going on with it. And again, the threshold is also higher as to the allegations. It's a different kind of hearing. So for today's purposes, the findings have been made.
Is it possible that you could put in like some kind of writing that I want Waterbury when they do let me back out, and I would like them to immediately put the referrals to the IOP and stuff that they have me going to do, so I'm not sitting on my hands and feet waiting.
Yeah, and by then you'll also speak with your attorney, who's also gonna, normally they submit some information, so they're gonna speak with you as well. At your revocation hearing, once we go through it, if we need the halfway house placement, I'll put in your requested area for sure.
Do we know how long this, I know what?
You know that it's up to Parole and Community Services to find housing. I mean, the best I can do with some of it is up to them.
But last time they only did it because it was an emergency situation.
Yeah.
I don't want them to mess up and think I'm getting out the 17th when it's really the 7th again. Like they made a mistake last time. And then it had to be an emergency release. So I got stuck in that. The place was hell. I don't know how anyone makes it.
Yeah. Yeah, so I will, once we get through the revocation process, whatever's needed, it will just be part of the information provided to PCS of your recommended location. So the revocation hearing will be myself or another hearing examiner, and we'll determine if you did violate the conditions of your parole, and also if you did, there will be a recommended sanction regarding whether your parole should be revoked and what's going on with that. So that happens within 60 business days of your remand.
Now, in terms of severity, like, how much time is this type of violation? Like, is it looking at like 4 years or?
I can't say because I don't even know if I'll be the one to do it. I'm sure I probably will be,
I'm
but
just
it could be
asking
any
your
of us.
opinion. I'm asking an opinion. I'm not holding you to like,
Yeah, I
oh,
can't
she
give
gave
you
a
a total
guarantee.
opinion.
I just
Yeah,
want an opinion.
we look at a bunch of stuff. The attorneys, when they contact you, will give you more of an understanding of what's going on in it. Ask them those questions because I really can't
Unfortunately,
tell
I
you.
tried to ask Sonia Jones before and she told me I don't want to give you any opinion.
Well, I mean,
I'm asking you an opinion because I mean, you seem like you're down to earth and you can give an opinion.
I am, however,
I get
I
there's
don't know.
determinate factors.
There's a lot of factors and I don't know much about you besides what was given to me. So at that hearing, at the revocation hearing is when the other factors come into play. And that's when the decision's made. It's
Well,
not
it's
made
my third
before then.
violation, but it's my first technical.
Oh, okay. Well, Mr. Howard, I'm going to end this hearing because I also want you to know that anything you say here can be used against you. So we're going to stop the hearing because we've concluded the preliminary process
Also, we're
at this point.
Can we scratch that last part then?
We're just going to stop it now. So you are all set for today. Your revocation hearing will be scheduled within 60 business days of your remand. And at that time is when you can provide additional information. And I will note that you would like an attorney, okay? So you're all set, Mr. Howard. Good luck. Take care. This concludes the